So let's start with arbitration. Say a little bit more about arbitration, please, Nadia.
So arbitration has a long history, and it is in the international field the most popular form of dispute resolution. Typically, parties come to arbitration because they sign a commercial agreement, a transactional agreement with the people they're working with, and in that agreement there's an arbitration clause which says that in the event of a dispute between the parties, they'll refer the matter to arbitration. Arbitrators are specialists in their field. They're not necessarily lawyers. They could have a construction background or an engineering background or a medical background, depending on the context of the dispute. And their job is to hear formal submissions made by the parties and to make a decision which the parties have agreed in advance to be bound by. The decision is not just based on law typically, but can also take into account trade usage, commercial principles, equitable principles as well. So in that way, it's different from a court of law. And it's not even like a private court of law because, of course, your arbitrator can be the person of your choice. Arbitrators often work in teams of up to 3, particularly in a cross-border setting. And in a cross-border setting, there's a range of legislation and conventions that also regulate the enforcement of the arbitral awards.